8, good. Okay, we're on? Okay. Call a special council meeting for Wednesday, January 24th to order. First item of business on the agenda is to approve the application for exempt permit LG 220 for the Minnesota Chapter National Wild Turkey Federation.
Mr. Mayor, I'll make a motion to approve the permit for the LG 220. The Minnesota Chapter of National Wild Turkey Federation as presented.
First and a second?
Second.
Second. All those in favor?
Aye.
Opposed? Carried. Second item on the agenda is to approve city administrator contract, council motion. So we're here, we wanted to extend this, we were asked to hold this off until we had the whole council present. The whole council is present. Does anyone want us, do we want to start with discussions about this, or what do we want to do? What's the council's, or do we want to, what? How do you want to proceed? You guys have as I can.
Well, I can,
Yeah, some discussion.
Okay, so how do we want to discuss? Do we want to go item by item? Or are there certain items, are there specific items that people have questions about? Or is it, the whole contract, or what? If there's specific items, we can go item by item. Basically, we would go, one through the entire contract and just see where there are agreement, where there isn't agreement. How do we, we can proceed that way?
Yes, I would say before we went item by item, I would like to talk about the process of getting to a contract like this. You know. how
So are we
got to this
questioning,
point.
how are we questioning the contract, how the contract came to be?
Correct, how the contract came to be, the information in the contract, the data behind the numbers in the contract, the same process that we're using to evaluate all the other employees, unions, stuff like that.
Okay. The contract is, with the exception of the original contract, as I've stated prior, when people, to those who have asked, was drafted and developed by David Drong and Associates in 2017. And that the council in 2017 agreed that with this contract that was developed, and the city administrator at that time agreed to the terms of the contract. The contract has not changed since that date. This contract has come in. The only changes are, for in language wise, is in the original contract, numbers 5, 6, 7, and 8 are now simply 5 and 6 in this one, and it has to do with 5, 6, 7, and 8 have to do with sick time, vacation time, holidays, general insurance. Okay, and in this contract, that's all wrapped up into the two items that number 5 and 6, benefits, annual evaluation, and then benefits. If I remember, if I read it correctly. So 5, 6, 7, and 8 are all wrapped up into number, mostly actually, it's written up into number 6. And
So I guess, before we get into it,
And-
be more specific with my question is the new contract, you stated Dram and Associates wrote the first contract. Who wrote the second contract?
it's the same contract. What the city administrator has done is, this is the first time in 7 years that in reading this contract, she asked for, just like the unions do, when they put together a list of demands, list of, wants. She put into this contract the things that she was asking for with the council. What does the council want to do? That's why this contract was given to everybody to review and get back if they had questions about any particular items, etc. These are just this is her wish list.
Okay,
Those items, that's her wish list. Okay. So just like the unions give us a wish list, and then we meet as a council to discuss what do we want, what do we agree to, what don't we agree to? Where do we want to go from here? What are we willing to offer on this or that versus what they want, et cetera. That's what this is. The difference is that we can close a meeting to do that.
Sure.
Can't close a meeting to do this.
No, and that's fine.
Okay.
Um,
So that's why it was the contract as with the items that were being asked for was given to each council member. And my email was pretty specific that if there was any questions or problems, issues, whatever, to get them back to myself and then because we can't obviously give them back to her, it's her contract. So we would then get those answers from whomever needs to give the answer. If it's, if it has to go to the labor attorney to get an answer, if it has to go to, the finance or whatever to get an
Sure,
answer,
sure.
you know, we can, and some of the information is already just here. I mean, it was like the information that you asked for yesterday, we got, you know, some of that information can be provided to us and then we can, you know, come in and sit down and ask questions that we have, but,
sure.
um,
And so I guess my question with that, you know, and changing this contract from 2017 to date, the initial position and I'll say employee qualifications and job description and stuff too. Even when I read through this current contract and something that hasn't changed, you know, administrative clerk, treasurer position, you know, from the original one till now, you know, I'm just wondering what has changed from 17 to today to 24. And, you know, can we see the comparisons? Cause I think the role, the job, the position, maybe what's being done today is not also the same thing that was being done back in 2017, if that's fair to say. I mean, obviously we've hired other people even for certain parts and roles of that job when this contract was originally put together in 2017. As far as like treasurer clerk positions, you know.
Have you looked at the old contract?
Yeah, I have the old contract here and I have the new contract. And so that's what I'm saying. I'm just looking and going, okay, let's look at it as a whole then.
Mhm.
You know, let's look at the job, let's look at the job description, let's look at everything in entirety then versus just terminology and changing some terms in the contract, you know.
Yeah, that's really nothing.
there, yeah, what terms were changed though? Like I was saying, number 4, item 4, is relabeled compensation versus salary is what it said in the original.
So
Those are
like
the-
number
those are
one-
Those are the changes that I saw in the contract as, other than the things that what she was asking the council to consider.
So like, I mean, if we just start on number 1, the original contract said administrator, clerk, treasurer. Now it just says administrator and treasurer. So obviously, when the original contract was written, there was job roles and descriptions for clerk. But now that is left out of the new contract. So I'm saying, where's that data that now shows that, you know, what the changes are from, obviously, the job description was also clerk, it's left out of here.
Okay, I see what you're talking about. Okay.
You know, so
So your concern is that she's doing less than what she was originally hired to do.
well, I'm just saying there's a change there, and where's that information? I'm not saying doing less. I think the job has probably changed, but I'm saying if we're gonna look at a new contract, we have to look at the job description hand in hand. Because right off the get-go, a title has changed, a role has been dropped.
Okay.
So that's gonna,
Okay, this is the
impact-
first I'm hearing this. That's why I'm asking.
well.
Haven't heard this from anyone prior to.
Well, it's not new news, you know, I'm just pointing it.
Well,
it
it's new,
out.
what I'm saying is this is the first we're hearing this as a council and this,
And that's
again,
what this meeting's for.
yeah, but that's why if that was information that was being sought, that's why we were trying to do it. That could have gotten an answer. We could have got an answer. Okay, so,
Well, I mean, I didn't write it. I mean, that's a difference in there. I'm just pointing out. There's, you know, I've gone through and highlighted in all the areas you know, because it's actually pretty significant, the changes. I'll agree that they're minor in words and language, but the meaning's significant. So that's, I guess what I'm saying. So that's where,
So that's one, all right? Got
right,
that.
and
Where-
and so I guess that's why I'm asking, what's our process to
So
go
we're gonna
through
go,
this?
what we're gonna do is we're gonna go through these each one at a time, 1, 2, 3, all the way through it. And then we're gonna find out where all the concerns are, so then they can be addressed either tonight or if we have to do it in a
But
different
that's not even my
fashion.
question.
Well,
My question is, what is the process that the city has in renewing a contract like this? You know, what are the other pieces? The first time this was done, we had an outside company come in and help do it. They did an evaluation on it. They put the contract together. They do this for other cities. They did all this work. Why aren't we doing that process this time? Why are we gonna go line item and muddle our way through it? Why aren't we gonna have an outside company come in?
Process here is that first you have a contract that was made by an outside company. It's the same with the other contracts we have for our other employees as well. I mean, as far as it's made by a third party, that this job descriptions are made and verified by the city attorney. All of these things are done from start for any employee that we have. Then this, for this particular position, we have, for the city administrator, then anything, the old, contract and the new contract, the one with her requests in it, was given out back in October for us to review.
Mhm.
And that process then is for us to give any issues that we may have in writing so that we can bring that up to her and do a negotiation in closed session, you know, not closed session for the, for us as a council, but as for the personnel committee can talk with her about this then. Like what we would do with the unions, it's just that the personnel committee does that negotiation with the unions. So we could have done that ahead of time here. Instead, no, nothing was brought up.
Right, but
That was
I just got
incumbent
these-
upon us to go ahead and do that work, which was never done. So in other words, you're bringing up these issues right at this point where it's an open session like this. It's not very, I don't think it's a very good way of approaching it. We had asked that we give these issues ahead of time so it can be done in a more, not trying to muddle through it like you just said, to take care of those issues before we have to come up to a session like this.
For sure, and that's why I called you 2 weeks ago. That's why I called John a couple weeks ago. That's why I emailed stuff out yesterday. My emails.
But
with
you've
questions.
never written anything down and presented it to the council or to Jenny or anyone here. I never
have an
received
email-
anything.
I have an email right here with responses back from Jenny and John
yesterday.
yesterday, yeah. And then I also contacted both of you on the phone, and you said October, but John, you just emailed this out in
I
December.
emailed you, when was the evaluation meeting?
October 24th.
Okay, on October 24th, every member of this council got a copy of the employment or the contract that Jenny was asking for. Okay, when I emailed out asking for stuff, you advised me you did not have a copy of the contract. Okay, every one of us got one that night. I had mine. I mean, so I don't know, but then what I did was I emailed out to everybody a copy of the contract and the original. And I asked, because having not heard anything since October, the assumption was that everyone was okay with it.
And when you called me 2 weeks ago to mention all these items, that's when I asked you, please put down in a bullet point so that I can bring this up, but I never did get that.
Right, and I was on the road traveling. Like I told you on the phone, I didn't have the ability to email. I was traveling.
Hmm.
I've been gone. So I did shoot over an email, but I don't know that,
Because I shot the email that went out to everybody,
sure.
the second email, when you said you didn't, that was December 27th. Is when that email went out.
Yeah, and that's all
the
great. And
information got out, and it was December 27th. So the only way to find out whether we need to have a second party draft a whole new contract, which is what you're saying, potentially, is if we go through each and every item and find out where the problems are or they aren't. That's the only way that I know how to do that. And that, to Mark's point, that would have been done in such a way that we could have got the issues out, we could have verified with people what was going on, get answers, and then each member of the council was also said, it was very plain in my emails that come in and discuss these. If you have questions, come and discuss with the city administrator what it was that you had a question or issue with. Nobody did that. So, do we want to take these one at a time or what? Jesse, what do you think?
Both sides are good points. Apologize for missing last week due to the wedding, but I have some just initial points and I apologize for not bringing them up prior. We think we've had quite a bit going on
Yep.
towards the end of the year. So regardless, we're here now. So it is what it is. The term of the first agreement, what was the duration of the term of the first agreement
It just renewed, automatically.
when you were hired on?
Correct.
It was a 5-year agreement?
No, it just continued,
Okay,
just,
If
understand.
neither party brings up any requests, it just continues and renews.
Sure.
That's what it says.
Okay. And then the lump sum versus the COLA aspect, the lump sum is, the lump sum of 5% is to reflect essentially
In
the
the
cost of
price,
living,
yeah.
but it's nothing above and beyond that. So the
Lump sums or cost,
it's number 4.
Yeah. It's
Number 4, lump sum.
Yep.
There's nothing above and beyond that, correct? That I would think I'd be missing.
you're looking at number 4.
It's in number
for
4.
the base salary, you mean?
Correct.
Yeah, that 5% included in that base salary, I believe, right?
No,
It's not?
lump,
That's just a
the lump
strange,
sum is exactly the same. The lump sum payment, it was the same thing we did with all the other employees that were outside of the pay grid. They were above the pay grid, they're out of it, okay? They all got 2.5% lump sum. It's not longevity per se, but it was a way of giving them something to say towards. That was something that was negotiated through, I believe, the supervisors union, if I'm not mistaken. And we agreed to that as a council, which is fine. And that lump sum payment is just that. You're outside of the pay scale, you're outside of the step process.
Sure.
And
but
and we
I
gave
think the
them
one-
that 2.5, that doesn't go on to her base salary. That does not affect her base salary. If it was longevity in the terms of what longevity has been come to know, then yes, you would add 2.5% to the base salary of an employee, okay? And then that's the true sense of what longevity was considered back when. Longevity is something that is not being typically negotiated in the contracts anymore. That's what our labor attorneys have said. And it has been a question that the other unions and the unions have asked for in the past. We've always, as a council, turned it down.
A bonus.
Well, you
Mhm.
can,
It's a bonus.
you can call this a bonus if you want.
That's what it is.
No,
Yeah.
longevity is not a bonus. Longevity is, yeah,
No, right.
longevity
Lump
is,
sums are bonuses.
Is that typical for
What?
government, for municipal government?
longevity.
No.
No.
They're-
No, that answers
Yeah.
no to that.
A lot of them are going into this bonus.
Yeah.
But I think it's when it's the 5% every year.
Well, the lump sum payment in and of
That's-
itself is not in addition to, on top, that's a thank you for staying, just like we did with the other employees. It does not go on to the base wage. Therefore, the next COLA or the next increase you get is not going to be based, that's not going to affect that. It's a one-time lump sum payment.
So
I think
what,
I
So
was just gonna look,
so-
I was just gonna say this, it says So if we look at number 4 under it, in bold letters is lump sum, says employer shall pay employee a 5% lump sum payment off of employee's base salary each year, payable to the employee in January of that year. I think
That was a request.
right. I
So
know.
that's a request, but let's stop a second and let's back up. We're talking about this form right here with the pay scale. This is a question I posed to both of you on the phone, also in the email yesterday, and I got the information back. So we have this pay scale that we have referred to at some points now with some employees. We have a pay scale now with yet somebody else outside of the pay scale. I brought this up at a previous meeting talking about this. If we have this document put together that we say that we're gonna use and we're gonna follow as a city, but we pick when we use it and with what group we use it, why do we have it?
How
Right,
did
Mark?
we-
You're shaking your head, yes.
How did we?
And
pick it?
so why don't we look at this
And change there.
and change this first before we talk about this? Because the only thing that's been consistent is the inconsistency. Now, not saying with us, but looking back. Because we're like, oh, what did they do 2 years ago? What did they do 3 years ago? Well, why did that group do this? Why did that group do this? Why don't we fix this so we can actually follow it? Because once again, it's not working. And once again, we're outside of the box, as you just said, John. And
I didn't
we,
say outside the box. I said
yeah,
we're
you said
the
outside the
scale.
pay scale.
Pay scale.
So
big
we're outside the
difference.
pay scale again. So why don't we fix the pay scale for situations like this? Because
Why they're outside, the reason they're outside the pay scale, Joe, is because there's 9 steps to the pay scale.
correct.
Those employees who have been here and started at the bottom of the pay scale and went to the 9-year step, and then number 10, 11, 12, whatever, they're getting a COLA adjustment every year. That's what they get. They don't get the additional 3% that is the separation between each step in the pay scale.
But-
The other thing with the pay scale is that if you start out and I'm gonna use the police department because it's probably the easiest one to show. If you start out as a police officer and you've been here for 6 years, 7 years, maybe you're here for 9 years, and all of a sudden you get promoted to sergeant, okay? You're gonna go back in the pay scale. You're going to go up in pay, up a position, okay? But now the next step that gives you a pay raise is going to be step, say, 6 of the sergeant's pay, okay? Just for an example. So you went from, you've been here year 9, but now you're back at step 6, but in a higher pay scale. That's how pay scales work.
I
If you go from
understand
sergeant
all
to
that,
chief,
but
okay.
what I'm
So
saying
what
is
hasn't been followed is, I guess I'm
there's
with
there's-
respect to the city administrator, which is what we're discussing, what hasn't been followed?
there's just no guidelines. It's not that nothing's been followed. There is nothing to follow. That's what I'm saying. There's nothing to follow. What do we do to increase? Also with a lot of
Where did
the
we-
long, well,
Where
Just-
did we start?
let me finish.
Please.
So this came up before with the unions and long-term employees too. They're outside of the pay scale. They've either gone as high as they can go and been here as long, and they're outside of the box. This is not the first person or in the first situation that we've ran into this with. And what do? You know, a bonus, what do? We want to keep employees here at the city of Nisswa. We want to encourage them to work here a long time. It's the best for us to maintain people like that. I'm saying, let's look at this, like Mark said too, let's look at this and ways to correct this. So we have these answers, so there is something to follow, because right now there isn't something to follow. What we are following is, oh, this is what we did with that group last time or 2 times ago. And we're always looking backwards to try and figure out how to go forward. Why don't we create a map so we can just look ahead instead of looking backwards on what we did last time? That's what I'm saying. And also too, I want to just remind everybody too, these decisions that we're making here, obviously there's staff and union representatives here too. We're setting a precedence tonight
Mhm.
on what the union's gonna ask for next time, because they are also in the same category. And I'm just saying, this needs a little bit of work and time and thought put into it before we answer this question.
Okay, we are doing a pay study. We did a pay study 3 years ago. And the pay scales were adjusted accordingly, and we adjusted the groups accordingly. And we admitted that we've always been in compliance with state law. One, we've always been in compliance with comparable work. The city, since 2017, when we adopted the pay scales, has never been out of compliance with comparable work. We haven't always been in compliance or close or within the margin of error of our comparable cities, which we fixed. And now we're doing another pay study. I believe it's ongoing right now as we speak. The company we hired is doing it. And they will get back to us sometime. I believe we should have that information around March. And the city, first of all, the city council agreed, and the personnel committee relayed to each union, as well as the non-union employees, that when that pay scale study comes back, the city agreed to stay, the city council, us sitting here, agreed that we would keep our employees within the margin of error. And that means that if we have to adjust, then we adjust at that time. That's what we're doing. That's what you're asking about, is with that. That's adjusting your pay scales. How do you adjust your pay scales? You adjust the pay scales just like the company that put it together for us said. Sometimes you may have to drop a bottom scale and add it to the top. So that would mean that year 1 is dropped and everything moves up 1. Year 1 and 2 are dropped and everything moves up. Adding to your increasing your scales so that you can stay in compliance, both comparable worth and with your comparable cities. And we've made that promise to the unions that we would do that moving forward. We also admitted that we thought we were being in compliance, but we weren't doing it right as the city. So we've been doing exactly what you're saying. And I don't want to put words
So
in your
why
mouth.
won't we wait for that data in
So
March
you're
before we do
so you're
that?
suggesting that this contract be put on hold until we have that data?
I think that there's a lot of data that we need, and that would be one of them. I mean, if that's ongoing and it's coming out in March, why wouldn't we look at that and do this,
As far
Because
as,
I want to create consistency.
as far as I'm concerned, it's a good idea. We should always be looking at this, always be open to make adjustments as necessary. That's a no-brainer in my mind. So I agree with that. But to say that because of that, we can't approve a contract here for our city administrator, I think that's a big mistake. Because we've approved all the other contracts, with that bonus in there as well. To say not to approve this is not very fair in my mind.
Not
So-
just that, but we also approved it with the knowledge that we may have to do something to adjust those pay scales as well for all of the employees. Whether they have a settled contract or not, the personnel committee made it very plain to the unions, whether we have a settled contract or not, is not going to change the fact that if we're not in compliance, we are going to have to sit down as a council and figure out how do we get in compliance? Not necessarily, it doesn't have to wait till the next contract is open. It can
Right.
be done with a letter of understanding too.
And I don't
So-
disagree with you. I'm just saying it doesn't have to be done tonight because that took
Yeah.
months.
Right. It'll take time.
Yeah, so.
And we need to have that
think
new
we're gonna
market
do
study
something here
too.
Tonight, I think is premature.
And we need to have that market study as well.
Right.
So I agree with that.
But I also think that we're getting off, that we're discussing this contract, so. Since we're doing that, here's my question, and just like we would do at any union negotiation, which we've always done at union negotiations at the behest of the council. The public or the personnel committee only discusses with them what the council has allowed us to discuss. We can't make promises. We can't do anything. We only discuss what you guys, this group as a whole, has said we can discuss. So the first question is on the base salary issue for 2024 reflects a 5.5% wage increase, which is what all the unions and the rest of the employees got within the city. The contract, her contract has always said, and what she's always received, what this position has always received, has been that of whatever the non-union employees get. Okay, that's what's in the contract. It's on multiple sections of the contract. That's what
So-
she's always got.
What's on multiple sections?
What the city administrator gets for increases in pay, et cetera, is equivalent to whatever the non-union employees get. So if the non-union employees get a 3.5% increase, she gets a 3.5% increase. Because the contract is the terms of employment, the employee shall commence employment under the employment with employer under the terms of this agreement on August 21st, 2017, and shall continue until such employment is terminated in accordance with this agreement. So that means that this thing just continues on.
Right.
Okay. She's never asked for anything, but when it comes to wages and stuff, wage increases and everything, it is, she gets the same increase as non-union employees. Same with sick leave, vacation, everything. It's all the same as the non-union employees.
On COLA.
Yeah,
COLA.
More or less.
COLA, whatever. I mean, if the unions negotiated, if we settled 5% with the union, for example, but the
Right.
non-union employees only got 3%,
Right,
okay, she would get 3%.
right.
Okay, so
Sure.
that hasn't happened. We've always been pretty consistent, COLAs across the board. So what she's asked for, again, this is a request, just like the
Right.
unions do. She's asking for a 5.5% increase for 2024, which is what everyone else has got. Everyone else in the city got a 5.5% increase this year.
Yep.
That's what we agreed to. So she's asking for 2024 for a 5.5% increase. Are we okay with that as a union? Or as,
Yes.
excuse me, as a council, are we okay with that?
We're okay with that.
Okay,
But-
so then in 2025, she's asking for a 5% increase in salary, which is what we agreed to for the Teamsters, because the Teamsters contract is a 2-year contract. So are we okay with that?
That's a union.
But
That's
that's a
the
union.
Union. Okay,
So that-
but are we okay with the 5% increase? Or is the council gonna say,
Well, you just said it follows the non-union. So what's the non-union?
well, that's, well,
So
you-
right
you-
now we're
okay.
flipping back and forth.
okay. Do you wanna go on record right now saying what we're gonna give the non-union?
Well, the whole contract
mean-
though,
But the point, no, we're just talking this one item right now.
well, hold on.
5%, no, 5% general increase for 2024. That's what the Teamsters are getting. Okay. Can we, or do you see us giving more than that or less than that to the other unions and rank and file employees?
Well, this is for a 3-year contract though.
Yeah, but
So the term of the contract, yeah, so
so the
3
second
years,
year,
5 years
but
for
the
what
second
term?
year, the second year of the contract, this contract, she's asking for 5%, and that's equivalent to what we gave the Teamsters.
But
Okay.
it's not, because this is a 3-year contract, so that's not equivalent. Because you gotta add that multiplier in here.
No, no, no. She's not, 2025, she's outside of the pay scales, just like a number of employees are. Okay, so 2025, this position is, so do we agree or disagree that a 5% increase, which is equivalent to what the Teamsters are getting, is acceptable? That's the question.
No, we disagree because
Okay, so
this
you're a no.
contract that we're still talking about is a 3-year contract and is not even the same as the Teamsters. And you just said she follows non-union and now
Okay.
we're following the union.
So then
We're just all over the board.
so what we're sending here is a message that the non-union, I think it's safe to say that if we follow our historic norm for the past, well, since 2017, that 5% will be the max that we're willing to give anybody else
For how many years?
for whatever the term of that contract is for that year, just for that year of a contract. It's just that year of a contract.
But
Year 3 is to be determined.
But the contract we're talking about, as it is written, is a 3-year contract.
What's that have to do with it?
What has everything to do with it?
No, Joe, we're
Because
talking
it
about the
renews.
wages for a single year. If the Teamsters right now have a 2-year contract. That's where the 5% comes from. So if the question is, the answer is, no, hold off, or whatever, everyone has a right to say what they feel about 2025.
2025, in my opinion, should reflect what 2026 is as to be determined, looking at the line. General increase for the calendar year will be provided and under the same conditions as the general increase provided to all other non-union employees.
Okay.
So it just
Right.
trails exactly what the next year is.
Exactly, and that's what this
And it could
was,
still end up being what you just,
it could be what it is, it could be more, it could be, I don't,
this consistency, I think will be better for it.
Okay.
Obviously, we're already in calendar year 24, so,
right.
what are your thoughts on that?
Yeah, I mean, that's what I'm saying. There's nothing for us to follow. We're not following this.
Do you want to put how does everyone feel about this item? We're gonna go through these item by item, because,
Right.
To be determined.
so that's 3 people,
4.
okay? To be
be
four? Fine.
determined.
Okay, so to be determined, fine. Okay, so that would be our response to that issue, okay, to that item. 26 is to be determined. On the next item that was asked, she asked about.
Which line item are you on?
Well, it's just
We're on, still on number 4, we're under lump sum. So,
I have a
Number,
question on that. if I
okay,
may.
yeah, so the employer shall pay employee a 5% lump sum payment off the employee's base salary each year, payable to the employee in January of that year. Okay, that's what's being requested.
I have a
Okay.
question on that one, if I
Sure,
may.
go ahead.
What are the other employees of the city getting on that?
The other employees got 2.5%.
Okay. I would think that that is a fair number to offer to the city administrator.
For how many years was that contract at 2.5% with the other employees?
It's a 1-year, it's a one-time thing.
Okay,
It's a one-time thing.
so this
Okay,
says it's
so-
a 3-year thing.
Correct. Okay.
So, yes, so no for 3 years.
A
Okay.
one-time for
2.5%.
year, a one-time in calendar year 2024 to be paid in the month of January as the rest of the employees have received.
Just for this year. That's it.
If there's nothing that the rest of the team is getting
Nope, nope.
in 25 or 26, I understand this is an employment agreement, but, me leading my company, if I was the only one to take a bonus in 2025 and I said sorry to the rest of my staff, I would have anarchy on my hands. I don't
Well,
want that.
this, and again, this was, again, I can't reiterate it enough that this is why
I understand,
know,
and I
people
take full responsibility too.
should have come and asked her,
On my
you know what?
side.
I came and talked with her about that, and I expressed my, I came and discussed all of this with her because once I read through everything and I had it down, I expressed the same thing, that it should be 2.5%, the same as the rest of the staff, and a one-time thing only. It brings up another question. It brings up other, ideas and things, but that's for a discussion between the council, in the future as it evolves into employment stuff. That would probably be had at a closed meeting before we negotiate with the unions and stuff, should it be brought up again. But that's something that there's some opportunities here for the city to show the employees that, you know, we want them to stay. So there's some opportunity here.
If we do,
Okay,
if we do another
but-
one in 2025.
Whatever.
For the staff,
Well, yeah, but-
absolutely, we would include the city administrator. It's not
Right.
just gonna be one side or the
Well,
other.
I think I'll clarify what I'm trying to say without, I don't want to put the city council, I'm not going to put any city council in a spot. But when you sit down, I'm not hot to trot on longevity coming back into contracts and stuff. But there is a possibility that if we sit down with the unions and say, okay, what's fair? How often? How many times? When does it happen? What's the trigger? You know, is it when you get your 10-year step, when you've been here for 10 years? Okay, and then when's the next step? Is it another 4 years, you know, you didn't get, you don't get longevity every year. You got to work X number of years, you get it. And then there's years between it. So what does that look like with the city working with the unions? What does that look like? Opens up some possibilities where the city can get some extra money into the pockets of the employees and help them out from time to time. But it has to be affordable. It has to be, how do you want to do that? Okay, that's why I'm saying it opens up some possibilities down the road. But for tonight, are we all, I don't know, the three of us are 2.5. Mark is one time or, okay, okay. Mark?
Yes.
Okay, so it's the same, okay. Next item we had is, severance or termination benefits, as they're called. That's item number 14. The old contract or the current contract, let me say, the current contract we're working under is 3 months. The city administrator is asking for 6 months. I did do some research on this. It's all over the board. There is no set time. What I saw most consistently was 1 month per year of service. So people that had 6 years of service, 7, 8, or whatever. What I couldn't find out was where's the cap. Okay, and I don't know how that,
I can tell you state statute allows up to 12 months maximum.
but
The structure of a severance package can equate to that of a bonus program for any given company. And there is nothing that's ever right. And it's always based off of the type of industry that a company is in.
Okay.
A tech-based company, I know for a fact, has paid out individual that I know an entire year's salary as severance.
Yeah.
We're not a tech company. We're a municipal government. I want to be on track with what is the norm because we're a 2,000 seat municipal. So what is standard and what's out of line? I think 6 months for a municipal, just by my pea-brain understanding, is a little bit aggressive. I think 3 months is more than fair. The terms in here for the payout of it, I mean, based off of the conditions of it, I didn't have much feedback on that.
And then this is a line item that having an outside company help us, what's normal, what's fair, what's going on out there would help to give us some insight. Right. But at the same time, we want to be fair. And so if, was it Dram and Associates? Is that correct?
Drown, yeah.
Brown. You know, if they're doing this, and obviously did this last time, I would say just stick with what they originally said.
Okay.
No changes.
I personally have no issue with 6 months. I know that the city of Hibbing gave their last city administrator a year. That was actually not their last one, but a few years ago, they gave John Fido a year point. I mean, it's, I mean, to the
Nothing's
state
perfect.
statutes point, they gave him that. We found, you know, as employees, given the circumstances of Mr. Fido leaving. But that was something that that's what the city did. Also, I think it's, you know, you look at this, if there's the whole list, there's the list of 1, 2, 3, 4, 5, 6, 7, 8, 9 items here that if, you know, and I'm sure that's not all of them. I'm sure there's other things that would fall in there, but if the employee is terminated for any of those reasons, then that doesn't come into play. They don't get it. I don't know if everyone read that. Okay.
The city attorney have any feedback, based on the conditions of a termination and triggering any of these events to then where said severance would need to be paid out? 1 through 9, and, it's the second to last paragraph in 14.
If the employer at any time during employment terms reduces, if the employer at any time during the employment term reduces the salary or other financial benefits of the employee by a greater percentage than an across-the-board reduction for all non-union employees, or if the employer refuses following written notice to comply with any other provisions of this agreement benefiting the employee, or if the employee resigns following a formal suggestion by the employer that she resigns, then the employee may, at his or her option, be deemed to be terminated on the effective date of the employee's resignation, and the employee shall be entitled to receive the termination benefits as set forth.
So on that note, then, my question for you would be specifically, who is the employer in this governmental type setting? Is it an individual council member?
No,
Is it the council's direction? The wording of it was really peculiar to me.
Is this the original wording?
I think so. Let's see.
I believe if the employer at any time during the employment reduces the salary or other financial benefits to the employee by a greater percentage than an across-the-board reduction for all non-union employees, or if the employer refuses following written notice to comply with any other provision of this agreement benefiting the employee, or if the employee resigns following a formal suggestion by the employer that he resign, then employee may at his or her option be deemed to be terminated on the effective date of the employee's resignation, and the employee shall be entitled to receive the termination benefits set forth above. Yes, it's the exact same language.
Verbatim. Okay.
I mean, I personally have no problem with 6 months, but that's
And-
a council decision.
Actually, I have no problem with that 6 months either, considering this work that this is a new, was a new position back in 2017, and I think that there's been some resistance to it. And I believe that it's been very difficult she's been in a pressure cooker. The administrator has been in pressure cooker system here. And so I am not, she's the leader of the group, the liaison between the council as well as the staff employees, and that's a very difficult position to be put into. That's not like what these supervisors have to deal with. They have to deal with her, but they don't have to deal with the council like this. So I think this is a very reasonable issue or item to request. And that she has been, this is now the 7th year that she's been here. I don't see that as much of an issue. I often did that at my company as well for long-term employees.
I'm okay with the 6 months.
Yeah, no, because we're setting a precedence. You know.
For the city administrator position.
and
That's my
for-
point.
And for other positions. It's-
No, I'm referring just as city, this is a very different position compared to supervisors. I know that they may ask for that. And that could be considered too. But my point is right now, this is at this position right here. That's why I'm agreeable to the 6 months.
Yeah, no, I mean, I also have done some research, you know. Rather than calling to Hibbing, I called the Pequot, Cross Lake area towns around here. And there's no language like this with any local contracts, not even at the 3 months.
You mean
Pequot
to
doesn't
say
even-
there's,
Pequot does not currently have a contract with their city administrator.
Correct, they don't even have a contract up there.
Yeah.
So I mean, at 3 months, we're already above and beyond, and at 6 months, no, I mean, once again, I'm saying no for several reasons. The taxpayers. The precedents we're setting, and then also too, we're not, like John just said, Pequot doesn't even have this for their person, any of this. And so we're not equal to comparable cities around us, even at this point.
I think that compared to other cities, as far as the salary of our of our maybe city administrator, there's adjustments that should be made, in my opinion. And that will be done, be revealed with the market study.
Yeah, let's wait for
Mm-hmm.
that, you know? So, yeah, so no, 6 months is way out of line with anything that I've seen. And also too, I mean, like I say, for the taxpayer, it's not in line. It's not in line for a city this size
That's
for what
not,
we have going.
I don't believe it's out of line.
So we have two, Jesse, you were,
I don't have further, reason to increase it from 3 to 6.
Okay.
So, the contract was in place when she was hired on, so we're not, you don't exactly take that away. So, we're already at where we're at. I'm gonna, side with Joe as well to where it's 3 months rather than 6.
okay.
I'm fine with the 6 month
And me too.
because of the without cause stipulation in there for termination. I mean, I don't think anybody else that works for the city is under that same stipulation.
Right.
What about all the part-time hourly employees? They're all at will.
Only the non-union.
Right.
Right.
So we have lots of non-union employees. So that's what I mean. We're setting a precedence.
Yes and no. I mean,
So
There's
I
a
can
significant
look at-
difference between her position and another employee's position when you're at the city administrator level. I think that, and there's another section coming
Yes.
up here that will address that actually too. So, but I'm just keeping track of where everyone's at here. Hang on different stuff. The last item that she had asked about had to do with on the new contract, it is item number 26. The old contract, it would be item number 30. Okay. And again, the difference in numbers is because the number of sections were combined into one, so it makes it a much easier to read. Arbitration of differences. So on the original contract, any breach or dispute arising out of or regarding the interpretation of this agreement shall be submitted to the Bureau of Mediation Services for binding arbitration of said dispute. Pursuant to the rules and procedures thereof, this article shall not preclude employee from submitting a breach or dispute arising out of or regarding the interpretation of this agreement initially through any initial city appeal or grievance process. Okay. In other words, she can start with the city personnel policy. What has been asked about changing that, and when honestly, I ran this has all been run past our city, the labor attorneys, okay?
hold on, John.
And-
John, I asked you that in an email yesterday.
No, Joe,
And
Joe-
you said no to that answer. You told me no in an email. So today you're saying that this has been looked at and
do
gone
not
over by
twist
somebody
my
else.
words, Counselor Hall.
brought
What
the
I
email.
brought up to the labor attorney was item 30. Okay, item 30 was the only thing the labor attorney said. Any breach number arbitration of differences, that is something that they do not see in
contract.
contracts like this. It's new to them.
So this was
Um,
looked at by somebody else and written by somebody else.
No, it was not written by somebody else. Will you be quiet and let me finish?
Okay,
I gave you I gave you the same courtesy, Joe, please.
right, you're
What
just
the-
telling me a different answer right
What?
now.
No, I am not. You're not listening. What the labor attorney said is this is not something that she normally sees in a contract, and it was suggested that, probably isn't something that the city would like to see in a should have in a contract. So what the city administrator came up with instead, since that was something that I discussed with her, was that the come up a different style language. So what she's asking for is that the employer-employee agree to negotiate all disputes between them in good faith for a period of 30 days from the date of the notice of dispute, prior to proceedings to formal dispute resolution or exercising their rights under law. Any claims or disputes unresolved. In other words, we're going to sit down and talk and try and solve what the problem is. Always a good thing. Any claims or disputes unresolved after good faith negotiations will first be submitted to the mediation utilizing Minnesota District Court Rule 114 roster. Any claims of disputes unresolved after mediation may be pursued as established by law. This section 26 shall not apply to any disputes that arise between the employer and employee regarding performance reviews of employee. So it's mediation. It's not binding because that's not how mediation works. And it makes us basically sit down and discuss the disputes, but we're not bound by arbitration.
John, can I ask a question?
Yes.
Sorry, maybe it helps clarify. Did you just bring up the issue of arbitration to the labor attorney? Because I think that's what Joe was getting at, is did the whole agreement get reviewed, or did you just ask that question in a vacuum?
Right.
This is the question I asked her.
Just that.
This question. She had a copy of the entire contract, obviously, so she could read it.
There could
No.
be some confusion about
Yeah.
that. I
Yeah.
don't know.
But no,
No, the labor attorney did review the entire contract.
the entire okay,
Yes.
fine.
You
Yes.
just, the email stated yesterday, John, you just told me.
You
that was
asked me
not
if we
done.
had, your email asks, read it out loud.
John, when I spoke to you, you told me that there is an outside company that put together the new contract and reviewed it. What are the notes? Can I see their notes? I'd also like to see the wage and contract study that was done to compare to our similar cities.
To the city attorney.
similar
May,
cities.
okay,
Right.
to the city attorney, may I ask you, is there a difference between drafting a new contract and reviewing an existing contract? First of all, our labor attorney did not draft a contract, which is the question you asked.
No, I didn't say anything about a labor attorney. I asked where this came from.
An outside agency, you asked it, an outside agency look at or draft this contract. Yes, in 2017, David Drown and Associates did it, which I told you.
Correct.
This year, nobody drafted, no outside agency drafted anything. They reviewed language, yes.
Did they suggest this language?
The only thing they said was they didn't, this has never been seen in a contract. They have never seen it. They wouldn't they did not.
So that's
Something they
that's
put
my
in.
question. Where did this language even come from?
This language came
Who
from
made up this language?
the,
I can answer that question.
sure.
So the labor attorney said that they didn't like the language, didn't offer a suggestion, which would have been helpful, to be quite honest, but I went to a fellow city administrator, city manager in Bemidji, and I asked for his contract language because he was just hired by the city of Bemidji, and that's what the contract language was. I gave that to the mayor for review, and the mayor said that that would be a good alternative. So that's where that came from, as an alternative, because the labor attorney said she didn't like the language that was there.
And I reviewed it as well.
Now, would you rather have arbitration or mediation? I would rather have mediation. In my opinion, arbitration takes away our inherent managerial right. So,
For me, I guess I'm more in favor of just having an ability to discuss these issues for the 30 days to try to resolve issues before we have to go to anything.
As adults.
And
as-
we have
as
that.
professional adults.
Right.
Where I see this and presenting, I guess, a presented argument as to why this couldn't be striked to its entirety, perhaps.
I mean, take it out completely,
Correct.
Well,
everything.
and then it
26.
goes back to my original question. Why are we fumbling through this, and why aren't we using an outside company that does this every day to help us with these issues, obviously?
We normally don't fumble through that with any other contracts like this. This is based on the older contract. And it's just some minor changes made by other people.
Jesse, can I try to answer that question you asked?
Yes.
Pretty common to see mediation provisions in contracts of all sorts these days
For employment,
for pretty much anything to suggest a process short of litigation. And to require people to talk, as you're talking about, first informally and then through a mediated process before people jump to litigation. Because sometimes people just want to jump to litigation. So to funnel that into a discussion that may avoid that is pretty common stuff.
Okay.
I think advisable here, I think the mediation process is advisable over the arbitration process. If I were to make any changes to this, I would change the title to this to say, not arbitration of differences, but resolution of differences.
Yeah.
And I would get to this first line on the next page where it says the date of the notice of a dispute prior to, I would strike proceeding to formal dispute resolution, because that's what you're getting rid of in getting rid of the idea of arbitration. So those are some cosmetic changes I would recommend to this. But the concept of guiding disputes, if they can't be fixed with discussion internally, to a mediation process, which is collaborative, and instead directing people to an arbitration process, which is not collaborative, right, is the way you want to go. And a provision like this is a good one, and it's a good one for the city.
okay, understood. Again, the outside expertise,
Right,
I-
and
I
that's,
wanna-
that's
I-
my question. Where's the expertise coming in all this?
And we could have had a lot of these answers if people had read the thing and gotten back to us ahead of time. I'm just gonna leave that at that. But here we are. So do we agree or disagree on swapping out the arbitrational language for mediation language? Is that something that we do or don't want?
I would say that we would have our city attorney write that up properly with what he just stated and
Mhm.
wait for that from him.
Joe, I would just say, the only thing is the things that I said, which were cosmetic changes. Otherwise, the rest of this new red line language, that
Okay,
this looks just fine to me.
so let's just put those changes in there. Do you have
Correct.
those notes, John?
Not yet.
Yeah.
So
I
we
have
would
them right
change
here.
it to resolution
yep,
of dispute
Of differences.
difference.
That's the title.
then striking the
And then
line,
you wanted to strike which,
striking a line within the first sentence, next page.
After the word prior, after the words prior to in that first line,
Striking proceeding to formal dispute resolution or
there you go. Yep,
all the, yep, from there all the way down to
that's right.
I have no other comments on. And Jenny, do we have that wage study coming back for sure in March? It is, okay.
so then we'll go back to issue 14, issue 6. Okay. Um,
We're at a tie for the lump sum. Still. I think that's the only outstanding thing, unless there's anything else that anybody needs. to bring
No, I
up.
think,
Well, there's other note.
no,
Are
I
you
think
done,
we were
John?
all- I think that we were all,
So there's, I
I
would
thought we were all in
The-
agreement.
the-
in the
Yeah,
2.5, yeah.
the lump sum.
2.5%.
2.5%.
No, it was the, sorry, not the lump sum. It was the 14.
There's Jesse and Joe are, stick with 3, Mark, and John are at 6. Okay,
All right,
but that's there. Number 26, result, differences. Or that, not results of differences.
resolutions.
Thank you. Of differences, we are all good there, with the changes that we discussed, the strike through. Issue 4, we were all there. What was the, our other item? Did I miss? No. Oh, that's because item 4 is 2. Okay, yeah, that's what I'm looking at. Got it. Yeah. Okay. So that's there. So, those are the requests those are the changes that are being
Well,
asked
hold on.
about. So I got
We've
that.
missed a bunch of changes. Let's go to the professional development unit. Read that. That's
Oh,
changed.
yeah.
Oh. Okay.
Yeah, I have that highlighted. I missed that too, Joe. Thank you. May I?
Yep.
The one that I specifically have highlighted, it's number 8.
Okay, thanks.
Let's see, it's towards the end of the paragraph, quote, with one designated specifically for the National League of Cities Congressional City Conference in Washington, DC. Ultimately that the employer, city of Nisswa, shall pay ordinary, reasonable, and necessary travel and subsidy expenses for employee for professional and official travel. That would mean to Washington, DC.
No, that's not, my understanding is that it's not being paid by the city for her to attend those. Right?
Currently, as part of my league board duties, correct. I mean, at some point I won't be on the league board, so that would change, but that wouldn't be until the fall of 25.
Okay, they pay for it until you are not on the board anymore, right?
Yes.
Okay, do you understand how I read it that way, though? It just states employer, going back in the middle again, employer also agrees to grant employee the option of attending up to 2 out-of-state conferences annually. With the precipice of the verbiage mentioned above, that the city is to pay for the travel expenses.
Well,
Follow me?
I guess with trying to keep it simple in the language to say, you know, presumably that this is a long-term contract, that would be the impact at whatever point that the travel expenses aren't being paid by the league board. I didn't want to get into all those details. We certainly can,
Yeah.
but just trying to say generally, I mean, if another organization is going to, you know, pay for that, of course, that's what I'm going to do.
So I think what you're concerned is that whether we're paying for it as a city or not.
Right.
And so to make sure that the language is that way.
Yes, absolutely. I mean, I've been to DC a dozen times. I mean, I know what it costs to go out there.
Yeah.
Staying at a Super 8 or, you know, the former Trump Hotel next to Capitol Hill, or the White House, I mean, so. That's my only feedback on that note, is I don't know if it's the city's responsibility to compensate for the cost to do that for a event that's, I understand you're part of with League of Minnesota Cities, and I believe that's an affiliated event. It doesn't really seem exactly something that the city of Nisswa should be compensating for. Does that make sense? Okay.
I would agree with Jesse.
So maybe what we could say is that as long as she's on the board, in other words, they're paying for it.
The board's paying,
Then it can just
League
be
of
left
Minnesota-
out of this language. It's irrelevant to us then.
it should just be, if there's something like that,
Well, I know that there has been objection from some members, not on the board here, or not on the council, but that she's even on the, being the president of the League of Minnesota Cities. So this is to allow her to attend those. The board will be paying for it, but this is just to allow her to go.
for sure.
Because I see that as a huge benefit for the city with the
Not-
connections.
Definitely not taking away from that. It's precipice
The compensation
of the
of it.
cost of it.
Yeah, the cost of it.
In the same paragraph for the professional development.
Yeah,
We would just leave
I
it
can
out.
see what you're saying,
Yes,
but
that's how I read it, and that's how I'm sharing it.
you could say something that the board, that it shall not be a cost to the city. Somehow say it that way, but I could see where if some people object to her trying to go to this, you know, and then cause trouble like that.
Or just add the verbiage unless approved by city council prior.
Yeah.
If she's gonna go to Washington DC and advocate with Stauber for 6 days or 7 days to try to get us a city water
Exactly.
funding, that's a different story.
Yeah,
I understand it. We all understand it's a little bit
Yeah.
more transparent, but then.
That all
again,
needs addressed back to begin. That all needs addressed in the job description. That's where that needs addressed, in the job description. What do we want this person to be doing?
this is an elected position that was we
No,
are
no, no, no. The city
very happy
administrator.
to have her in that type of position. But that's something that's only temporary. It's not
Correct.
something that'll continue on a
I
contract
would just
like
say that
this.
we leave all the language out and just leave it as is. Just leave it alone. Don't change anything.
What the wording as it is right now,
Yeah.
just leave it alone.
Wait, are you referring to what the original one?
What the original contract, just leave the original contract alone.
Okay, I have no problem with that as long as she's able to go, as part of the board, and it doesn't cost anything to the city.
Yeah, that's a time off scheduling thing.
Yeah, you wouldn't disagree with that, would you?
No, it's just, like I say, it's a
Okay.
time off scheduling thing.
Mhm.
Okay.
Oh, you're talking about taking vacation time off.
Once again, goes back to job descriptions and what do we want her to do?
Mhm.
Does she take time off now or is she getting paid from the city while she's doing all the league stuff?
I believe her job description already stipulates economic development, which is that would probably, if we were gonna send her out there to, like, to Jesse's point,
Right.
talk to Congressman Stauber and lobby to, for something along that line, that would fall directly in there, which is
But
already.
once
a
again,
job
it's all
description.
something as a part of this that needs brought up to speed. Because when, she started in this role, she wasn't doing anything in that realm. Now she's doing a whole bunch in that realm.
Mhm. Which often happens in positions that are within a company, within government.
Correct. That's why I'm saying there's such a bigger picture that we still need to look at here.
Mhm.
So also, another thing is just the term of the contract. Back to the first thing,
Okay.
asking for a 3-year contract. That's another change.
Yeah. Thought we went through that one already.
We talked about, but we didn't address it or
What's your suggestion?
just leave it alone. No renewing yearly. Because once again, back to how is it for all the non-union
Well,
and what are we following? And if we're following that criteria there, we need to follow it here in the terms.
The original contract was renewing.
Just renewing every year.
Yep.
Yep. But this would automatically renew the pay raises and stuff for the next 3 years.
No, so there's no.
We have it to be determined.
Pay raises.
I would just leave
She
it
gets a
alone.
5.5% increase this year, which she's gonna get because under the old contract, it's there already. And then she asked for the 5% based on the reasons we explained. And then the council said to BD and for 25 and for 26. Okay, so, I guess I'm missing what am I missing on what you're saying? With the 3-year contract, why is there a problem with we have a 2-year contract with the Teamsters, we've had 3-year contracts in the.
Well, I guess, maybe a question for the attorney, how do you interpret this renewal? I'm interpreting everything in the contract as automatic renewal.
Which one are you looking at, Joe?
2,
Everything, yeah, okay,
shall,
Be the 3-year contract.
you're looking.
this shall continue for a period of 3 years, meaning that everything in the contract shall continue. The wage increases, everything shall automatically continue for the next 3 years. It's not excluding any of that stuff, the way that it's written.
Of course
That's the way I'm reading it.
Okay,
It doesn't have
I
a
believe you're reading it
conclusion.
wrong because 2026 is to be determined. There is no stipulation of a wage increase beyond
But
two.
John, that's not even the item that we're on. We're on number 2.
I understand that, but you're saying that she's going to continue to get the wage increases.
Well, that's where I'm asking the attorney, what's the interpretation? You know, I think I need a clear interpretation of number 2 that then tells us what you're talking about.
I'm just not sure what you're unclear about.
So I guess why would we even, so then I guess somebody needs to tell me what the difference is of having 3 years in there versus just leaving it alone the way it is right now.
The old wordage.
Right. So if there is no difference, then why even put the 3 years in there?
Is this the old wording?
No,
No.
the old wording is
Do you have a copy of the old wording?
I don't.
Yeah, right here is the old wording.
terms of employment under the old wording is employees shall commence employment with the terms obviously stipulated, shall continue in such employment as terminated in accordance with agreement.
Here's the whole pack.
That was the term of employment.
So Joe, it's a 3-year contract, right? But it's terminable for without cause. So it's a 3-year contract. I don't know why that's different than what was previous. I gotta admit, I'm not sure what and shall automatically renew thereafter means.
That's what I'm asking.
I don't know what that part means, but the 3-year contract, I can't speak to that other than just to probably guess that it's probably a market concept. I don't know. Jenny maybe can tell us. I don't know why the 3-year as opposed to the previous, but my guess is that's the way it's being done these days with city administrators in cities of this size. That's my guess.
So, yeah, so those are all questions that I'm asking. Why a 3-year contract? Why?
Jenny, do you want to give us your input as to why you're looking at a 3-year contract?
I just felt that it provided some kind of consistency to say, I'm not looking to have this conversation every year. We don't have to negotiate like we went the 6 years before to say like everything is good. I just felt that that would be a good, and if there were no issues in 3 years, we just carry on, like was done before. It was just a thought and an idea as far as trying to plan a little bit ahead, right? And do some longevity planning within that structure, but then
Yeah, I'm
not
okay
having to
with,
go back every year.
yeah, I'm okay with the 3-year contract. I know a lot of, well, I shouldn't say a lot of. Some of the municipalities that I've been talking to, when they hire a new administrator or manager, they do a 6-month probation. After that, then they go into a contract. Not all of them, but the majority of them that I talk to have, and sometimes they do a 5-year contract. Which then would be looked at after the 5 years. I'm fine with a 3-year contract, but then after that,
So then maybe the language needs
clean it up.
written differently or explained?
Okay, well,
Because I had
The only thing I think that could be, you could say is vague in that is the last 5 words that say and shall automatically renew thereafter.
that's correct. I
When I read
mean,
that, I don't know what
And that can come out.
so
I understand why that's in there. I think,
striking of the verbiage shall automatically renew thereafter.
confines that to a discussion again in 3 years about what this
Right.
looks like, right?
Exactly. What's the point?
So does that also say a discussion won't take place for 3 years?
No, it'll be
Implicit, isn't it?
correct. I mean, we'll get to the point prior to the expiration of the contract where we will then get into another round of this. But additionally, if we,
Yeah, I would,
the 6-month severance for a 3-year term is different than a 3-month severance for a annual term. Just noting.
I often went without a contract for a long time as an executive. But they wanted to go to contracts and we would make 2, 3, 5-year contracts because they wanted to have the ability to keep coming back and forth with the negotiation. Previously, it was just slid right by, nothing,
Sure.
and it becomes automatic that it caused trouble that, say like if they let me go, I could cause them trouble by doing that. That's why they wanted to have the contracts. So having a 3-year contract to me for this type of position does not bother me at all.
I don't have an issue with it either. Because of the other terms and verbiage in here, there's enough. You guys have anything else on this?
Am I missing a page?
You guys have anything else on this?
No.
Looking at
Now, do we want to take that verbiage out at the end?
Which one? Oh, on one.
For the 3-year
Keep the 3-year contract in there, but take the last.
Strike. Suggesting to strike the verbiage. No. Shall renew, shall automatically renew thereafter. I don't know what that means. I know what it means, but I don't know what it can entail.
I think the only, you can either strike it or you can put in there that shall renew annually thereafter. Which
No.
is what the new one says.
No, I would just rather go back into contract negotiation because it's gonna come back anyway. Because there's a base salary increase for 2024. We've already agreed. 2025, it's to be determined. Same thing for 2026. So you might as well run this thing to 2040 then, if it's gonna renew automatically thereafter. You
Right.
guys-
No, I understand what
Yeah.
you're saying. I'm just trying to, okay. So. So, Mark, what are you saying? Just so I know. Strike that,
I'd like to take that wording out.
okay, Mark?
We could take the wording out, but 3-year contract.
Jesse, take it out.
Correct, and I'm fine with the 3-year.
Joe,
Yeah, take it out.
are you okay with the 3-year?
Yes.
If that's what the 3-year means.
And I am too. Okay. So then that one. Okay. So. So then. The question is, with those changes, and we're gonna negotiate this again. So there's gonna be a negotiation in 3 years. Now, my question is because my understanding is that because this isn't, okay. I just brain farted the language. Because this is not a labor negotiation in the terms of we're discussing things with the union, can we have a discussion like we do with the unions with the city administrator? Can the council meet in closed session to determine what we want to or don't want to give her?
No, I think you've just done that, haven't you?
Yeah.
I think there are two choices here. Somebody makes a motion.
No, I don't mean on this contract, but in the future moving forward.
No,
Can we close a meeting to discuss what we do or don't want to offer, just like we discuss the wish list from the unions?
no, you have to run it like you have been, which is negotiations conducted by a personnel committee that then cycle into this process.
Okay. Okay,
And I would strongly recommend that if the items were sent out for review, to get those written recommendations back, so that we can do that through that type of process rather than doing it in an open session like this. This is a very transparent session, but I've never had to do that for myself, and it must be very difficult for the city administrator to be here while we're talking here like this. So I encourage that this be taken care of in the proper fashion in the future. And that those would be presented in writing as to those issues. Then the the personnel committee can do its function just like it does with the unions.
So I'd make a motion that we would table the rest of the discussion on this until after the wage comprehension study is done and complete to finalize the items on this process.
If you were to say that, then we shouldn't be doing it to anybody in the city here. You know, any of the contracts that we've done. I strongly disagree with that.
Mhm.
We need to, I think,
There's a motion.
So there's a
There's a
motion.
Yeah,
motion.
there's a motion.
okay,
Do I have a second?
then
Hearing no second, then the motion dies for no second. What I would, do we look at, redrafting with our revisions? Typically at that point, we would have it redrafted or redrawn up, with the changes that we have in place, that we've said, okay? And then it would have to come back again or, I mean, it would just be cleaner, I think, doing it that way than maybe, or we can just verbally say what our changes are that we're offering to the contract, or we could have it redrafted with the changes, the alterations in there that we're looking at versus what was requested to begin with. And then we would have to do this again to determine or to pass it.
Well, we all agreed though, correct, that there's to be determined items until that study was done, right? We just sat here and agreed to that. And so how can we go forward until it's done?
no,
You wanted to table this whole matter until the study was done.
Correct, because
that
that's
motion
what we just
died.
agreed.
That motion did not get a
Right.
vote.
So
Okay.
I'm
So
asking,
what I'm saying, I'm trying to make this, try and explain it here as best I can. We went through the items in the contract, item by item. We went through the things that the city administrator, her wish list of what she asked for. We made this changes. We decided what, there were decisions made on what should be changed, some of the languages that we want to see to be struck. It's a 3-year contract. We were all in agreement that the 3-year contract was fine with the one set of language that was struck. That means wages are to be determined, just like everyone else. The wage study may have adjustments made yet this year to everybody. We don't know that what's going to happen. But the point is 25, 26 is those are just terms of the contract. Okay. Normally in a union contract or the contracts that we have with the unions is those wages are predetermined. In other words, 5.5% for the Teamsters this year, 5% for the Teamsters next year. And we had already told them that we are going to incorporate the wage study into any alterations or changes that need to take place. And that doesn't have to take place even though the union contract is settled, we can do a letter of understanding if we need to. So so what the wage study says as far as like item 4 for the length of the contract and the wages to be determined, that's not an issue. They'll be what they are. So my question is simple. Do we want to go through and vote on each individual item here now? We've already pretty much done
I
that.
thought that's what we just did.
Do we want to go through and vote on each individual item, make it an on the record vote, actual vote, or do we want to redraft the requested contract changes that was initially requested of us, do we want to have this redrafted with the changes that we as a council just discussed, and then meet again to determine if we're good or not with it? That's my question to the council, how they want to do it. The other way to do it is to very simply say that somebody if we were to make a motion to accept the contract with the changes as stipulated by the council, we could do that too. Okay. That's the other question. But just like any other contract, does not the city administrator deserve to have it say, this is where we're at. She's been sitting here, but this is where we're at. Are you okay with that? Or would you like to come back with maybe a different position on something? Would you want to offer, instead of 6 months, do you want to offer 4 months? You know, just like we do with the unions. Except with the unions, we get to do this all behind closed doors. Do we want to do it that way?
Well, yeah, I think.
Why
we-
shouldn't
we
she
need
have
to
the
go-
same
Sure.
input?
Yeah, go back to her. And to Mark's point, doing this the correct way and the proper way in the future, great. There isn't a system set up because this has never been done in the city before. This is the first time. And
But it was-
that's why we're fumbling through this.
No, we're not.
No, we're
fumbling.
not, because
What's wrong here is that people were asked to give feedback and they refused to give it. They did not give it. They were for whatever reason, there was no feedback given. The contracts were handed out in October. There was no feedback from anybody. So the assumption then can only be made that, okay, I guess everyone's good with it. Okay, because if there's feedback, then we can get this behind closed doors answers, get it out to everybody. Does this answer your question? Does this not answer your question? Nobody did that, no one. And nobody came in and sat down with the city administrator one-on-one and said, okay, I don't understand what you're thinking about this or that. Okay, so the process, that was the process and it wasn't followed. But going forward, then if we're going to do a contract negotiation, just like we do with the unions, okay, then we need to give the city administrator position the same courtesies that we give everyone else insofar as we can. We can't close a meeting to discuss it, okay? But the information can go out in a packet and we can ask and we can say, okay, are we good with this offer or that offer? Okay, but we don't, you know, so in the future is what Mark was alluding to. I would like to know how we want to handle this one. The future will be the future, but right now, how do we want to handle this one? Should we just have the changes drafted up, which I think is what we should do? And then everyone can read it, make sure they're happy with it and they're good with it, that we didn't miss something, because we don't want to have to do this too many times. But I do think the city administrator deserves to have a contract, just like the unions deserve to have a contract, and just like the rank and file employees deserve to know what they are or aren't getting.
Mr. Mayor, I would suggest that even though we've made a lot of agreements with everything here, that the revisions be made, and then we have that at the next meeting, that we would go ahead, and then if we agree with those revisions, that they have not been changed as to what we had here, then we would go ahead and approve it at that time. I'd make a motion to do that.
But aren't we gonna allow the city administrator to look at it in between those points?
Yeah, that's what I'm saying. In other words, we make the revisions and then we'll be able to look at that, make sure that nothing was changed from what we agreed to tonight. And that way, then we can make we can approve it at the next meeting then.
So then the
Me-
motion is to redraft it per the discussion tonight.
Correct.
Then have the personnel committee take that redrafted version to a meeting with the city administrator. And then once that's complete, come back to the city council.
Correct.
And we can get all that information out to the city council.
Mm-hmm.
So they also have a chance to review it and ask questions of the city administrator if they want to.
Yeah, and but we'll take it to the city
Yeah,
administrator
Yeah,
first
make
and then
sure
do that.
everything's
Yep.
copacetic,
Mhm.
and then all the council members should get a copy of it. That once, okay, and then they can talk to the city administrator about it. Hopefully, making sure that everything is, if they have any additional questions. So, okay. So that-
Second.
Second, okay. All those in favor?
Aye.
Aye.
Opposed? Carried,
Mr. Mayor, can I make a point?
yes.
To the to be determined discussion that I heard tonight. I really don't know what's to be determined. The way this contract is written with the asterisks in section 3 about the 2024 salary and the indexing that's attached to that. And then the indexing that would occur in 2026. Those things, they're not to be determined. I mean, we don't know what the number is, but there's a process for how to figure out what the number is. So I don't know that that would hold up your eventual approval of this contract, even in advance of the receipt of the results of a wage study.
So not even just mention the second year, third year to be determined, just take that out?
No, I'm just saying, Mark, that as written with these asterisk provisions, they're indexing provisions. They already envision a process that will fill in what that number can be if it changes.
Okay.
Correct. And I mean, the asterisk verbiage for the double asterisk, for example, we don't have an increase rate for the other non-union employees for 2025 yet.
Right?
So what's your suggestion?
Well, I don't think that's written badly.
Right.
Again, it's what I've been calling an indexing provision, right? You're gonna index for 2024 based on the results of a wage study, the results you're waiting for. And when 2026 comes around, that's also indexed to a formula for how that's gonna go.
Yeah.
Yeah, and I think what we're to be determined on is like the information from the wage study that kind of talked about this.
Right.
Yeah,
You know, that was the to be determined. Let's see how the wage study impacts everything. And the comprehension, and then also it's a comparison. It also impacts the 3 months versus 6 months, all that stuff.
correct me if I'm wrong, Jenny, but I think the to be determined, in my mind, to be determined means whatever's negotiated for the non-union employees. That's the purpose. Okay, so we could change it to that instead of to be determined, it's a non-union employee. Or just leave it out.
Yeah.
Or just leave
It's
it the
fine the
way
way it is because
Okay.
it references the double asterisk, which has the terms. behind
Right.
it, So. He was just, good point, but.
Okay, yeah, okay. So then we will do that and then get it back to you. Does anyone have a problem if we sit down with the city administrator and redraft this, or would they rather have, Tom, is this something that we could ask your office to draw up our changes to if I get them to you, or we get them to you as a personnel committee? What's the best way for us to provide? Because I already know that there's going to be issues if the city administrator does it.
Go ahead and do that. I have, for the reasons stated previously, stayed away from these issues and am here against, well, not against, but not wanting to be involved in these kind of conversations for reasons stated earlier and why you have a labor attorney. But yes, am comfortable taking your snapshot of your notes, because I don't think I made any. So send those to me and I will take and put this into a red line that I think captures what you talked about tonight, that you would then, you and Mark, John, will take to Jenny to talk with her about.
Yeah.
So yes, I'm comfortable doing that if you want to give that to me.
Now, when I redraft this to make double sure that we got everything, okay, is there an issue if I send it out to the other council members to make sure that it's covered, or?
Yeah, there is. Yeah. You don't want to get into a closed
That's true. Corn.
situation and
Yeah.
serial meetings
Yeah.
and all that stuff. I mean, certainly
Okay.
your process
just-
of sending the contract, original draft contract out as the personnel committee to the group is not an open meeting law violation, because you specifically are saying, don't respond to this.
Yeah.
Email, let's not talk about this in emails. You proposed a process for that. So no, do not send the snapshot of the notes out to the group to get a thumbs up or a thumbs down.
All right.
So this leaves Jenny as the only city employee that hasn't had a modification go in effect for
Correct.
2024. It's worth
Well,
mentioning, just out of,
Didn't she get technically, she should get the 5.5% increase because that's under the old contract, which is still in effect until this happens.
oh, never mind, I take that back.
Yep.
Any
That's
further?
just like any other contract, the union, a contract or whatever. If you go with, if their contract has expired, everything that the previous contract said stays in effect. Okay,
Right.
so this contract says that, so she did get that, so, yeah. Which eliminates back pay issues. So, which is good too. Okay, so, that is everything. Okay. Yes. Two, 8, or 2, 4, 8.
I make
14,
a motion
20.
that we adjourn then.
I'll second.
Yeah, I'm sorry. Thank
Oh,
you.
we did.
Okay, all those in favor say aye.
Aye.
Opposed? Carried. Motion to adjourn?
I'll make a motion that we adjourn.
Second.
All in favor?
Aye.
Opposed? Okay, we're adjourned.